Okay, the last time, earlier, we were talking about the business judgment, we were talking about directors and officers. One of the things that we need to study, and that's very important, that we didn't really spend enough time on, was the business judgment rule. And I gave you a definition of the business judgment rule, and I gave you certain things that it requires of a person. Had a list of things, like 8 things, I think it was. And but I'm going to now give you a different definition and a much shorter list. Okay, but sometimes you need a long list, sometimes you need a short list. But the important thing is it's not that there's a list, because you're not. I don't think I don't take the grocery list kind of business serious in terms of learning things. I mean, you make grocery lists so you don't forget things when you get to the store. And you can make lists on legal rules and precepts, but you really need to understand the purpose of the thing. And so courts defer to the business judgment of corporate executives. So that's important to understand, that this is a case where the courts are going to say, well, these are the people that have been selected by the shareholders, and the people who have invested their money, and sometimes substantial money, have wanted these people to be on the board of directors. Therefore, we shouldn't be too harsh and trying to second guess them, and we don't want to discourage good people from doing it. So we're generally going to defer to their business judgment, and anybody who wants to challenge their judgment and sue in a derivative suit and make them pay some money because of something, maybe they lost some money on a deal, maybe that was the director's fault, maybe it wasn't. Was the director doing the best under the circumstances? And so maybe that should be the issue. So the courts defer to the business judgment of the corporate executive. And so we went through that and said, well, as long as he acted in good faith. But let me give you this other definition. The directors of a corporation are clothed with the presumption, and this is a direct quote, with the presumption which the law accords to them of being motivated in their conduct by a bona fide, that's a good faith. So basically we're going to presume they're acting in good faith. And if you're going to challenge their decision because you lost some money or it didn't come out the way you thought it should, then you're going to have to prove something. And one thing you could prove is they were acting in bad faith. What would that be? Well, maybe they were acting in their own self-interest and not in the interest of the firm, so they weren't being loyal. So we'll talk about that in a minute, the kind of things you need to look at. So I'll give you this short list in a minute. So one of the things is that a director needs to act in good faith and not be selfish, greedy. So as conduct by a bona fide. So we're going to presume that they are acting in a bona fide regard for the interest of the corporation whose affairs the stockholders have committed to their charge. Now, I don't know if you could have written all that down. That's quite a long kind of thing. I've oftentimes told students it's useful oftentimes to write things down because some people remember things better if they do that. So I always took notes when I was a student. I did very well. I don't know whether it was because I took notes or because I thoroughly read all the materials and came to all the classes, and would bite my finger to stay awake if I was sleepy in class. I don't know what it was, but I think that a lot of people I know, and I had a friend who said that he always wrote things down that he needed to remember. It says, because one time he told me something, and he said, now remind me of this tomorrow. I said, okay, I'll remind you of that tomorrow. I can easily remember that. And he said, okay. And then he started writing it down. I said, well, you told me to tell you tomorrow, and here you're writing it down. He said, well, I'll remember it better that way. And I think that he was right in that regard. So, is the director, so look at here, what we're looking at is a behavior that any shareholder wants. The shareholder wants the director to be acting in good faith for his interests, for the interest of the corporation whose affairs the stockholder have committed to their charge. And sometimes it's not even a question of how much money the stockholder is making. Maybe he just wants to see the corporation succeed. Some people invest in corporations because they're going to do good things So that's why we have benefit corporations, and we talked about that. And so, some people have some motivation beyond the selfish. Not everybody's a deep narcissist. Now, everybody, to some extent, will act in their own self-interest from time to time. And you have to, right? Because you have to live in this earth. And some of us, though, get a little carried away and are what are called by Mr. Green deep narcissists. Anyway, so the point here is that, all of us, when we are investing our money, want our investment, for whatever reason we're investing in that corporation, we want the director to do what's good for the corporation. And if the corporation is doing well, then we will profit. But it may be, in some cases, we're not really primarily concerned with that. In some cases, we may be investing in, say, some environmental company because we want a better environment, or some other company is going to help with charitable kinds of things. And so we are actually more empathetic than people oftentimes. What many economists, the basic assumption of economists have traditionally been that we're rational, and that we're rational in a way that makes us always interested in me, and in making profits. I'm not sure I subscribe to that anymore. When I was young, that's what I was taught, but I've seen differently, and I've met people who were differently motivated. So I'm going to give you a three-pronged test. So I told you I had a longer list before, and this is a shorter list. So maybe it's a better list, therefore. Sometimes more information is not an improvement. So the court will not review the business decisions of corporate directors who perform their duties, one, in good faith. So if the, basically you have to keep in mind that the good faith, bad faith would have to be proven by the party alleging that the decision was a bad decision and that it was wrong for the director to do that, okay? So he has the burden of proof. But if the director could actually make a convincing case that he was acting in good faith, that will help him win the case, because the other side has to make a convincing case, a very convincing case, that he's acting in bad faith, because the burden of proof, the presumption that the director has, is very strong, and the burden of proof is on the plaintiff to prove that he made a bad decision, which may have cost the man the money, but that's not why we do it. So he did it with the care that an ordinarily prudent person in a like position would exercise under similar circumstances. So that would mean he would take in for advice all the people who are expert on the issue at hand. So if it's a financial issue, you need to talk maybe to financial experts, accountants, maybe economists, and maybe others who can tell you something about the financial interests involved. And so they can't be potted plant. Directors are not supposed to be sitting there just listening and rubber stamping what's going on for that. So that's what they can't be. They gotta have a reason for making a decision. So that means that they have to have evidence. They can't just do it because they feel it's the right thing. They can't act on their gut instinct entirely. Now everybody to a certain extent will act on their gut instincts, and sometimes our guts are right, but sometimes they're wrong, and that's why you need to have the break of rationality to say, okay, this doesn't make sense. And that's why you also need to maybe have more than one person. So that's why the wisdom of crowds work. That's why getting more than one opinion works. And the good leaders will take into consideration the people who they work with, and seek others' opinions out. And will not only seek it, but will actually listen to it and change their decisions based upon it. Yes, they might say, well, I don't really agree, but it seems to me like I'm outvoted here. Or after listening to everybody speaking, I could see a different side to things, and maybe it's better if we do it this way, although I didn't think that initially. And so when you find a man like that, you've got a Lincoln. Now, you can think of some other leaders we've had that are not like that, are not interested in anybody else's opinion, and in fact will even deny the truth that's right in front of them. And number three, in a manner the directors reasonably believe to be in the best interest of the corporation. Of course, that they and notice there I'd say in the best interest of the corporation, not in the best interest of the director or even the shareholders. not in the best interest of the officers, not in the best interest of the employees, but in the best interest of the corporate entity. Corporate entity is there for a purpose, and it should fulfill that purpose. And oftentimes it has a benefit to society. So that's important. So we're going to look at a case here. This is a case that's in your book, so you can look it up. You can actually look it up online. I looked it up online because I wanted to read the entire case, because oftentimes I find that there's more into a case than that. But I think the book actually does, in this case, a very good job of presenting a very summarized version of the thing. The case that I read goes on for, I don't know, at least 10 pages. I didn't actually count it. It's just a bunch of pages, and that's not unusual for cases to do that. And there were a lot of things that were talked about that were pretty much dismissed. But that's the care with which these cases are handled, and that's what we expect from our judges, right? They get paid a lot of money to make the right decisions, and so we want them to be considerate of both sides, and we want them to actually produce for us some good explanation of what the case is. So the alleged wrongdoing in this case centers upon iStar, so that's a company, iStar's 2011 modification of restricted stock unit performance. The awards granted to iStar executives in 2008, and so the executives were given awards. And I guess the issue here was the shareholder who brought this derivative suit. He wants that these directors put the money back in there, and basically he says it was a bad decision. I don't know whether he was actually able to establish that. From what I read, I don't think that the court was conclusive in finding that it was really a bad decision. Yes, the stock went down, okay, but that happens, and sometimes that happens not because the decision was bad. You're making a decision oftentimes with uncertainty. You don't know what the outcome's going to be, and you don't always know what it is. So that's not the reason the court would find the directors liable and have to put back the award just because they lost money in a certain year. It'd be like your boss telling you, well, last year we didn't do very well, and so everybody here who's working for me has to take a cut. You would say that's unfair. It didn't go down because of me, and I was working for a salary. When you get a great big increase in profits, you don't give me a bonus that much, or you don't give me a proportional bonus. If you do give me a bonus, you're stingy with me, and you keep all the money for yourself. You may give yourself a bonus as a boss, but you don't necessarily give me that. So why am I having to pay for the downturn, but not getting the upticks benefits? Anyway, so iStar stock, if certain conditions were met, the terms of 2008 awards, and these conditions were actually met, which did not include necessarily continued rise in it, but there was a certain rise that was in the stocks that they did meet, but then it fell. If certain conditions were met, the terms of the 2008 awards provided that the awards would vest in if iStar stock achieved any one of 3 average closing prices targets over 20 consecutive trading days. So these are all successful periods. Now, we don't even need to think about whether or not it goes down after that, because that was the thing. They did meet their goals, their targets. The targets were a price of $4 per share by December 19, 2009, $7 per share by December 19th of 2010, or $10 per share before December the 19th, 2011. So you see those 3 dates on 3 substantially different time periods. So, so they met their targets. Are they responsible for everything that will happen in the future? No. Shareholder charges. Shareholders argue that the committee member Ridings, who was the primary mover on this particular change that was incorporated into the running of the corporation by these directors, that Ridings lacked sufficient corporate experience to make a proper recommendation to the board, and that Ridings was not sufficiently disinterested. Okay, so they had a man who wasn't sufficiently disinterested. Both contentions are baseless. Ridings has 40 years of business experience, so he's not an inexperienced newbie, and including service on boards of several public companies. That's probably why they called him, because he had this great wealth of experience and probably a good reputation. Including service on the boards of several public companies, including the American Stock Exchange. So he also worked for the American Stock Exchange. Furthermore, Ridings hired highly respected and experienced legal counsel to assist him and conducted multiple interviews. So the board wasn't being potted plants, they were just going with it because somebody recommended it. They were actually getting a recommendation from a person who has had business experience and a good deal of it. And also he had employed others to further advise him on the legal implications of what they were doing. And conducted multiple interviews with these lawyers. Director's defense. We further reject the shareholders' contention that Ridings was interested or lacked independence. Ridings joined the board after the challenged conduct and had no business, personal, social, or other relationship with any other member of the board. Although Ridings' employer, Lazard, performed banking services for iStar in 2010 and 2011, that may well be how they came into contact with him in the first place, and they thought, oh, this is a smart fellow, he'll advise us on this. And apparently he gave them good advice because they reached the targets that they had. Lazard has no ongoing business relationship with iStar, so he wasn't, by his employment with Lazard, when he made the recommendations, he wasn't necessarily looking to benefit Lazard. If he were doing that, that would definitely have been wrong, because that would be disloyal and might have been in his own, if it was in his own self-interest. He's not supposed to be making decisions in his own self-interest and not supposed to be actually participating in it. And maybe they would have had better luck if they went for why didn't you change course in the future at some time. But that's not what the case is about. So if you are going to bring these charges, you have to prove your charges. Furthermore, allegations of mere personal friendship or a mere outside business relation standing alone are insufficient to raise a reasonable doubt about a director's independence. So, you can't just make these allegations without having more evidence to back up your charges that he's not acting independently and he's serving his own interest. It's just not a matter of, oh well, he might be serving his interest or he might not, so you got to establish it. We're not going to assume that everybody's a deep narcissist. And the difference between a narcissist and a deep narcissist is that a narcissist is going to act oftentimes even very charitably towards others and going to have empathy for others, whereas a narcissist probably is largely incapable of being empathetic. If he acts in a way as seen as empathetic, it might just be a screen for something else. So he'd be like the guy who tells you he's honest John. That's just to get you to trust him, right? But he's not interested in being honest. So it could be a sham. The court's holding. In conclusion, the shareholders have failed to surmount the presumption. So notice that they're talking about the failure of the shareholders to surmount the presumption. They're not talking about the fact that Ridings or others have defeated some of these charges that they made. They're talking about that it was the shareholders who needed to prove something and they didn't prove it. So, failed to surmount the presumption of the business judgment rule. In failing to do so, they have failed to state a claim upon which relief may be granted. Now, it's an interesting case. This is a case where the court upheld the presumption, which is what you would expect, right? Because, it's sometimes hard to make a case and to convince others that somebody's done something wrong. You need to have solid evidence, and you need to be credible. And apparently they weren't there. I've seen there are cases where it can be proven. The reason I talked about potted plants was I used to use a different case, and that case involved a owner of the company. He was not the sole. He had controlling interest. What that means is if you own, say, in a large corporation, less than 50%, you might still hold controlling interest, because your 5% that you hold enables you to elect the majority of the board consistently, because so many people don't vote their shares. And so controlling interest is an interest that is less than 50%, that nonetheless enables a person to predictably elect whoever he wants to the boards. And so, you know, that certainly can be the case. And so in this case, the man had controlling interests, and he had a high percentage of stock, and he had personally, he was the CEO of this firm. He was the chairman of the board, which is not uncommon. You'll find that oftentimes in some corporations that's the case, and it's oftentimes the case where, you know, somebody has started a business, like for instance Henry Ford. Henry Ford was the CEO of his firm for years and years and years, and he was the chairman of the board, and he almost drove the Ford Motor Company into bankruptcy. Some people say it was World War II that saved it. Okay, but he was interested only in the efficiency of the car. He wasn't interested in marketing. So he was a great efficiency guy, great industrialist, very good engineer, had all these patents, and had produced a car that nobody thought was possible. But he wasn't as good a businessman because he wouldn't take into account the marketing. And anyway, so this particular guy had started his business and had actually loaded up his board of directors according to who he wanted to, because like I said, he had controlling interest, so he could put on there who he wanted to, as long as he gets a majority. All it takes is a majority, right? And you know, so he came before the board and proposed that they sell the firm to an outside firm that was going to buy them all out, And so all the shareholders would be given the opportunity to sell their shares to this new party. In the buyout, he would be given a golden parachute because he was the chief executive, and he would be substantially benefited by it. And he went before the board, and that was about it. I think he didn't. I don't think he actually supported it with much, but he did pass around some papers. Nobody knows who prepared the papers. You know, some sort of financial information that he presented to them. They didn't ask for more. They didn't ask for who made these papers. Instead, they pretty much nobody challenged him on his assertions, whether or not he was telling the truth. They just took what he said, and some of the things were not true. And so somebody brought a derivative suit, and they won on that. So you can win a suit, but you have to show bad faith and disloyalty. In this case, he's not only a director, but he's also, and he's a large director, and should you think, you might say, well, he should have an interest in having the corporation succeed, but he had more interest in making a profit from the sale of the firm because he wanted to retire. And he didn't care what happened to the other shareholders. So a shareholder who disregards the other shareholders, and sometimes it's a minority, sometimes it's, in this case it was not a minority, except it was only a minority in the sense that they didn't have control. There weren't enough shareholders to actually have control. He had control. A shareholder who acts in a way that disadvantages the other shareholders is acting in bad faith. If he's doing so as director, it's also a violation of his director's duty. So you can get him on both of those. Shareholders can be held liable, but it's rare, and you're going to have to prove that they acted in a way inconsistent with a duty to the other shareholders. And if he's director, you know, and you see these corporations that are like that, where, you know, some megalomaniac, some deep narcissist will take over and run the thing, and everybody answers to him, and everybody has to be a yes man, or he's not going to tolerate him. And, you know, at some point he might say to them, I don't want any yes men, but then he'll fire anybody who isn't a yes man, and he'll fire somebody else. Maybe if the guy might be seen by others as being a yes man, he'll fire him because others see him as being a yes man, and he doesn't want that either. You know? So, and he'll say, I don't want any yes men. Okay, and so that's a funny skit on the with the Monty Python players. It's a very funny skit on that. So they have failed to say, and the guy obviously, if you're listening to the way he talks, is obviously very much of a narcissist. and really probably wants everybody to be a yes man, but he just doesn't want it to be perceived that other people realize that they are yes men, or that they even understand that they are yes men. They've got to deny it. Oh no, and you got to put on a show somehow. Anyway, and it's a very tricky show to put on. So yeah, I don't think I'd ever want to work for a person like that. Would you want to work for somebody like that? Probably not. Anyway, so they have failed to state a claim upon which the relief may be granted is the end of that case that we had before. On the other hand, in this case where I talked about, one of the things they said was that these directors were sitting like potted plants. They were just there to decorate the room. In other words, you know, the chairman of the board, the chief executive officer, the guy who started the plant, he put them in there so that it appears that he's got a corporation full of directors, and he wants them to appear to be independent, and he wants to sell shares to other people because he wants to use other people's money, but he's not worried about whether or not they make money or not. He's interested only in what money he can get out, and if he can make more money by selling the firm out, he'll do it. And that's the trouble with working for a narcissist, or having a narcissist for a boss, or a leader, or whatever have you. They'll sell you out, and whether you realize it or not. And you might think that that everybody's like that, but not everybody's like that. And there are a lot of good people on that. I'm not saying that people don't act in their self-interest. They do act in their self-interest, but that's not always so bad. And some of them actually realize that they act in their self-interest, and when they realize it, what they're doing, their empathy maybe comes out, because everybody's also empathetic. We're born that way, you know. But deep narcissists have difficulty finding that empathy because they're oftentimes hurt by maybe having been grown up and taught by a parent or parents who didn't appreciate them and punished them and did all kinds of things that are bad for their psychological health. And so psychology is a very important subject. Once you understand it, you begin to understand how people are and begin to understand why they do what they do. Thank you very much for today. That's it for today. I think we maybe went overtime. Thank you.